not an exercise of constituent power, rather they are an exercise of ordinary legislative power. And that's why those amendments are not constitutional amendments. And those amendments are outside the scope of Article 368 of the Constitution. I hope this point is clear to you, because you have to be very clear about this fact. Please don't ever think that all forms of amendments of the Constitution are constitutional amendments. There are certain change, and by amendment I mean any kind of change that is brought into the Constitution, either addition, variation, removal, etc. So all forms of changes or amendment of the Constitution are not constitutional amendments. Only those amendments of the Constitution which are done under Article 368 of the Constitution in exercise of constituent power are considered to be constitutional amendments. Now, I will give you an example of what are those aspects of the Constitution which are not done in exercise of Article 368. Now, before that, let's just briefly look at Article 368. Now, Article 368, at least for the time being, you need to understand, has a procedural limitation. So when an amendment is made in pursuance of Article 368, it has to follow a specific procedure, and that procedure is enunciated under Article 368 Clause 2. And that procedure says that an amendment of this Constitution may be initiated only, okay? It is the only manner in which amendment of the Constitution can be initiated by the introduction of a bill for the purpose of amendment in either House of Parliament, and when the bill is passed in each House by a majority of total membership of that House, and by a majority of not less than 2/3 of the member of that House present and voting. So there are two requirements. That it has to be a majority of the total membership of the House, and also the majority of those members who are present and voting. So those are the two requirements. It shall be presented to the President, who shall give his assent to the bill, and thereupon the Constitution shall stand amended. Okay, that is one requirement. And there is also a second requirement that in certain instances, when Constitution touches upon some of the federal features which are mentioned under the proviso to Article 2, for example, Article 54, 55, 73, Chapter 4, Chapter 5 of Part 6, lists in 7th Schedule, representation of states and parliament, and Article 368 itself, what you also require is a consent ratification by the state legislatures. Okay, so there are two forms of amendments that are provided, procedures of amendment that are provided under Article 368 Clause 2. One, for those forms of amendments which do not fall in the proviso to Article 368 Clause 2, you require a special majority of total membership of the House, majority of total membership of the House, and a majority of not less than 2/3 of the members present and voting. And for those amendments of those provisions which fall in the proviso to Article 368 Clause 2, you would also additionally require a resolution by at least 50% of the state, more than 50% of the state. So that is the procedure. So there is a procedural limitation on constituent power, in the sense that constituent power has to exercise in a specific procedural manner. Okay. Now, there is also an implied or substantive limitation, and that substantive limitation comes in the form of basic structure doctrine. Okay. But we will discuss substantive limitation a little later. Let us just come back to our discussion wherein I was saying that all forms of amendment of the Constitution are not necessarily constitutional amendments under Article 368. All forms of amendments of the Constitution are not an exercise of constituent power. Now, for example, we discussed one example yesterday, that is Schedule 5. And in Schedule 5, let's just open and let us brush your memory with regard to Schedule 5. If you look at Schedule 5, okay, and you look at paragraph 7 of Schedule 5, paragraph 7, paragraph 2, and I hope you're carrying the bare act of the Constitution. You need to have a bare act of the Constitution. It says, no such law as is mentioned in subparagraph 1 of this paragraph shall be deemed to be an amendment of this Constitution for the purpose of Article 368. That means, and what is said in 7 clause 1 paragraph, 7 paragraph 7 subparagraph 1, that Parliament from time to time may amend by way of addition, variation or repeal any of the provisions of the schedule. So Parliament can amend, per se, Schedule 5 of the Constitution. But amendment of Schedule 5 of the Constitution is not a constitutional amendment under Article 368 of the Constitution. Because amendment of Schedule 5 of the Constitution is not in exercise of constituent power under Article 368 of the Constitution. Rather, it is an exercise of ordinary legislative power. Now, please have a look at Article 4 of the Constitution. Now, if you look at Article 4 of the Constitution, give me a second to read it out. It says, any law referred to in Article 2 or Article 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law, and may also contain such incidental, supplemental and consequential provisions as Parliament may deem necessary. Now, what is Article 2 and 3? Article 2 and 3 basically talk about formation of new states and altering the boundary of new states, establishment of new states, admission of new states. Now, any law which is made in furtherance or any changes any law which is made under Article 2 and 3, and 2 and 3 article would basically be about state reorganization. Okay? So let's say tomorrow the state of UP is reorganized. And as has been the demand for several years, divided into 4 parts. Okay? Now, if the state of UP is reorganized tomorrow and 4 different states are carved out of the present state of UP tomorrow, then you will need to have a State Reorganization Act. And that State Reorganization Act would have been formulated under the power vested in the Parliament under Article 2 and 3 of the Constitution. Now, if you bring about a state reorganization, please have a look at Schedule 1 of the Constitution. What you will also need to do is bring about a change in first schedule of the Constitution, because instead of state of Uttar Pradesh, you will have to add at least 3 more states, okay? Or you will have to add 4 more states instead and replace Uttar Pradesh with 4 more states. And therefore, you will need to amend or change Schedule 1. Schedule 1 is something which is very much a part of the Constitution. But this amendment of Schedule 1 is not an amendment of the Constitution under Article 368 of the Constitution. It is definitely an amendment of the Constitution, but not an amendment under Article 368 of the Constitution, because this amendment is very specifically kept out of the ambit of Article 368. So amending first schedule, or let's say amending fifth schedule, or amending fourth schedule, is Parliament exercising its ordinary legislative power to amend those schedules. Only in instances where Parliament exercises constituent power to bring about a change in the Constitution or amend the Constitution is it considered to be a constitutional amendment under Article 368. Okay? And basic structure doctrine is about constitutional amendment primarily about constitutional amendments. Now, let us come to the second leg of our discussion, that is, what is the substantive limitation under, we have discussed procedural limitation under Article 368, but what is the substantive limitation under Article 368? And for this, let's go back to what we were discussing in the initial part of our discussion today, that many of the laws which were passed by the legislature in the initial years of our independence were being challenged before the court, and the court was declaring it, in many times declaring it to be unconstitutional or something which is invalid. Now, the challenge before the legislature and the executive was that the court should not have the power to declare such laws to be invalid or unconstitutional, because the final arbiter of what the laws should be, or at least what the Constitution should be, is the Parliament and not the judiciary. Okay. So, the history of basic structure doctrine is marred with this tussle between legislature and executive on one hand and judiciary on the other. Now, what had happened, and this is just before Keshwanand Bharti in Golaknath judgment, it is few years before Keshwanand Bharti in Golaknath judgment, what the judiciary had held was that there is certain implied limitation on Article 368. And that implied limitation comes in the form of Part 3 of the Constitution. That is, fundamental rights are limitations on the power of the Parliament to amend the Constitution. That means that if an amendment is made to the Constitution that violates the Part 3 of the Constitution, then it is going to be considered to be invalid. Okay? So, there is a procedural limitation, obviously, which is very much explicit under 368 clause 2, but in Golaknath judgment, the court said that there is also an implied limitation, and that implied limitation comes in the form of fundamental rights. Now, this led to a huge chaos, and led to a very big struggle which was coming in few years. The struggle being that once you say that fundamental rights are limitation on the power of the Parliament to amend the Constitution, you are basically limiting the power of the Parliament to amend the Constitution. So now the Parliament does not have unlimited power to amend the Constitution. To an extent that Parliament cannot even amend Part 3 of the Constitution. So because Part 3 in itself is a limitation, so it sort of became immutable and fixed. That is the character that judiciary gave to Part 3 of the Constitution in Golaknath judgment, by giving it a fixed and immutable form of character, saying that you cannot go against Part 3 of the Constitution. That means that and specifically with regard to land reforms, I think the kind of repercussion that would follow, that if right to property was a fundamental, at that time right to property was a fundamental right under Article 19(1)(f), that means that land reforms would essentially be in conflict with right to property. And because the Parliament cannot make laws which goes against right to property under Article 19(1)(f), bringing about land reforms would have become very difficult. So not followed was a lot of struggle between legislature, executive of one hand, and judiciary, leading up to Keshwanand Bharti. Now, it will be very interesting to note that before Keshwanand Bharti, the executive actually tried to back the judiciary with pro-government judges, or at least judges whom the executive thought would be more inclined towards ruling in favor of Parliament having unlimited power to amend the Constitution instead of Parliament having limited power to amend the Constitution, or there being some kind of limitation on the power of the Parliament under Article 368 to amend the Constitution. Now, there is a very interesting book by T.R. Andhur Rajan, who was one of the lawyers in Keshwanand Bharti, and this book is only on Keshwanand Bharti. What was the different behind the scenes, what was happening in Keshwanand Bharti, apart from what actually happened in Keshwanand Bharti. And there is an interesting interesting fact that he quotes, that one of the judges who was elevated to Supreme Court just prior to Keshwanand Bharti publicly said that I am going to the Supreme Court to overrule Golaknath's judgment. So you can see the kind of tension that was there between the executive and the judiciary just post Golaknath judgment, because Golaknath judgment had held that the power of the Parliament to amend the Constitution under Article 368 is not unlimited, but is rather subject to limitation. And that limitation, according to Golaknath judgment, was fundamental rights. Okay. Now, what happened subsequently was that in Keshwanand Bharti, the question again before the court, among several questions. So Keshwanand Bharti case was about Kerala Land Reforms Act, and if you were following news, this week itself, few days back, the petitioner Keshwanand Bharti passed away. But you will be interested to know that there are accounts which say that when Keshwanand Bharti was being heard in the court, Keshwanand Bharti himself didn't know much about the case. And he was quite surprised as to why his name was featuring again and again in the newspapers. So again, I'm very interested, you would also be interested to know that in this entire lengthy decision, not once has the court discussed who actually is Keshwanand Bharti. So again, and it is something that you must have studied in Jurisprudence 1, when you were studying it, how selection of facts is also important in judicial determination. And this is one of the aspects for which law is often criticized, that law generally tries to be very selective about the facts. And the selectivity of the facts allows it to sort of disregard certain important aspects or applications or repercussions or consequences of law. Anyway, coming back to the topic, so Keshwanand Bharti case was basically the main question before Keshwanand Bharti case was whether there is any limitation on the power of the Parliament to amend the Constitution, okay, first. And if there is a limitation on the power of the Parliament to amend the Constitution under Article 368, what is it that the limitation is? What is it? What is the limitation? Now, what Keshwanand Bharti case said that yes, there is a limitation on the power of the Parliament to amend the Constitution. The power of the Parliament to amend the Constitution is not unlimited, but that limitation is not fundamental rights as was held in Golaknath judgment. So the entire Part 3 of the Constitution is not a limitation on power of the Parliament to amend the Constitution, such that the Parliament can even bring about changes in the Constitution or even in Part 3 of the Constitution itself. Rather, what exactly is a limitation on Part 3 of the Constitution is basic structure doctrine. So the limitation on the power of the Constitution to amend the Constitution is not Part 3 of the Constitution, rather it is basic structure doctrine. Okay. Now, the next question that may come to your mind is, what is it that is basic structure? Now, in Keshwan and Bharti, the court tried to at least describe or enunciate the content of basic structure. Now, some of them said it is federalism, some said separation of powers, etc., independence of judiciary, etc., secularism, etc., welfare state model. But you'll be, and this is a mistake that we often make, that but Part 3 entirely has never been considered to be a part of basic structure. Okay, so that is where Keshwan and Bharti diverged from Golaknath judgment. It accepted Golaknath judgment to the extent that there is in fact a limitation on the power of the Parliament to amend the Constitution under Article 368, and the power of the Parliament to amend the Constitution under Article 368 is not unlimited. But that limitation is not in the form of Part 3 of the Constitution as was held in Golaknath judgment, but that limitation is basic structure doctrine. And what is that basic structure? The judiciary tried to enunciate the contents of basic structure. Now, very simply speaking, if you have to understand basic structure in an extremely simplified manner, what you can say is that basic structure is that part of the Constitution which, if changed, would lead to the Constitution losing itself. Okay, it is the identity of the Constitution. Basic structure are the identity marks of the Constitution. Without it, Constitution has no value of its own. So those identity marks become the characteristic feature of the Constitution, very similar to an individual. Every individual has some distinctive identity traits, right? Such that if those identity traits change, you feel as if the individual has lost oneself and has become a completely new person. Very similar to that, Constitution also has some identity marks. And those identity marks are what a basic structure doctrine is. Such that if you change those features or those identity marks, you will actually be having a new Constitution itself. You will not be holding the previous Constitution. The Constitution in itself would have undergone a transformation such that it has become a new Constitution in itself. So it is those identity marks which is considered to be basic structure. Now, there is no checklist as to the fact that this is a basic structure. There is no comprehensive list. As we move along and as judicial development of this doctrine happened, several features of the Constitution were considered to be a part of basic structure, like independence of judiciary, the trinity of Article 14, 19, and 21, independence of judiciary, secularism, federalism, etc., etc. But never has entire Part 3 of the Constitution considered to be a part of basic structure. Now, rather in Keshwan and Bharti itself, Justice Khanna said that Article 19(1)(f) is not a part of basic structure. That is, right to property is not a part of basic structure. And because it is not a part of basic structure, the Parliament can amend 19(1)(f). And subsequently, there was a Constitution amendment in fact passed, which removed Article 19(1)(f) from the Constitution, and thereafter, right to property ceased to remain a fundamental right, and it only has the status of legal right, but not of a fundamental right. So, that is more or less the concept of basic structure. If you have any questions, please let me know, otherwise I will move ahead. Okay, if there are no questions, then let us try and understand how is it that the judiciary has tried to identify basic structure. Now, there are several tests, and at least for this semester, we are not going to go into all the details of basic structure, because if you have to understand basic structure, you need to read First Amendment, and that is not a part of the syllabus. Generally, I used to discuss the constitutional law basic structure in detail, but what that leads to is that we are not able to complete the syllabus and devote much time to the syllabus itself, and at least the last leg of the syllabus is rushed through. So I will not be discussing basic structure in detail this time, because that is something that we will eventually be discussing in next semester. That's why I'm just giving you a brief overview. Once we have time left after we finish syllabus, maybe we can come back to basic structure if you all want and discuss it in detail. Okay, so fine. So let's just come back to how does the basic structure operate, and what is it now? What is meant by basic structure is that while the Parliament, in exercise of its constituent power under Article 368, can amend the text of the Constitution, it cannot bring about such change in the text of the Constitution, such that it vitiates the identity of the Constitution. That means the Parliament can even bring about a change in the text of Part 3 of the Constitution, change the text of Article 14, 15, 16, 17, and so on. But the change in the text of Article 14, 15, 16, 17, and so on, 8, 19, cannot be in a manner that deprives the Constitution of its own essence. Now, for example, let's say tomorrow we have something called Article 19(1)(a), you must be aware of, so much in news these days, freedom of speech and expression. And then you have Article 19 clause 2, which provides limitations on freedom of speech and expression, several grounds on the basis on which are legitimate grounds for restricting freedom of speech and expression. Let's say tomorrow the Parliament, through Constitution amendment, amends Article 19 clause 2 and includes criticism of government as a valid ground for limiting freedom of speech and expression. Now, what an argument can be made is that by including criticism of government, what the Parliament has as a legitimate restriction on freedom of speech and expression, what the Parliament has done is that it has completely deprived, the essence of freedom of speech and expression is lost, because the idea of freedom of speech and expression includes within itself the idea to critique and dissent. And if the Constitution itself limits the right of freedom of individuals to critique and dissent, then it would lead to a collapse of the value or a failure of freedom of speech and expression, as if freedom of speech and expression right has no value in itself. And that is why such an amendment cannot be inserted in the Constitution, because that would lead to the Constitution being deprived of its essence. So while the text of Article 19(1)(a), 19 clause 2 may be changed, but the text cannot be changed in a manner that the identity of Article 19(1) or A and 2, or identity of the Constitution itself is lost. Okay. So now Article 19 has been considered to be a part of basic structure. So, but in a manner that the essence of Article 19 has been considered to be a part of basic structure, not in a text per se of Article 19. So, while determining whether something is a basic structure or not, or a specific constitutional amendment is a violation of basic structure or not, what is required is that we generally identify it by looking into the essence of the Constitution. So basic structure in that sense becomes an immutable part of the Constitution, something which you cannot change. And if you change that part of the Constitution, you will in a sense be formulating a new Constitution. Not that that cannot be done. Tomorrow there may be a revolution and constitutional revolution, and we come up with a new constitution altogether. And this has happened, that's why constitution is not fixed in time. Yet in our experiences, especially in South Asian nations at least, we have had our experiences of wherein every regime change has brought about a new constitution, or constitutions have been changed, several constitutions have been promulgated. So that is not an impossibility per se, but that's what they said, that if you change the basic structure of the constitution, what you are essentially changing is the constitution itself. Such that the constitution, if the basic structure is changed, we will no longer be having a constitution that was brought into force on 26 November 1950. Rather, we will be having a constitution, a completely new constitution that was maybe brought today or tomorrow, brought into force today or tomorrow. So that is the importance of basic structure doctrine. But what basic structure doctrine has eventually led to is the fact that now the final arbiter of what the Constitution is and what are those immutable principles of Constitution, that is basic structure, best is the judiciary. So the balance of power has today been shifted in favor of the judiciary, wherein the judiciary decides what is the Constitution and what are those immutable features of the Constitution itself. So in the struggle between the legislature, executive on one side and the judiciary, it is judiciary who finally won, in the sense that judiciary now became the final arbiter of the Constitution, which it can be argued at least may not be very much too much in consonance with the idea of how the Constituent Assembly or authors of the Constitution they wanted the Constitution to be, because they seem to be, at least that is in my understanding, and I may be wrong if you may have a different interpretation, at least in my understanding they seem to be in favor of not vesting too much power of judicial review in the judiciary. So the power of judicial review of the judiciary was expected to be a restrictive power, but through the advent of basic structure doctrine, we ended up giving power of judicial review in several senses to the judiciary, such that judiciary today becomes the final arbiter of the Constitution. Now, a question was asked in another section as to what is constitutional amendment is basic structure doctrine only about constitutional amendment or also about ordinary laws? In the sense that is the expectation to comply with basic structure only made from a constitutional amendment, or does only constitutional amendment have to comply with basic structure, or do ordinary laws also have to comply with basic structure? Now, if we take the Kelsenian methodology, okay, or Kelsenian idea of law, yes, ma'am, every law, that is completely correct. And I will just explain it to you why. That basic structure forms the higher norm higher to the text of the Constitution. Okay, I hope you remember Kelsen, when he talked about hierarchy of norms and lower norms deriving their legitimacy from higher norms. Now, basic structure forms the higher norm as compared to the text of the Constitution. So the text of the Constitution has to comply with the basic structure, and ordinary laws have to comply with the Constitution. So indirectly, they also have to comply with the basic structure, right? So an ordinary law not only has to comply with the text of the Constitution, but because the Constitution complies with basic structure, ordinary law indirectly also have to comply with basic structure doctrine. So everything has to be in consonance with basic structure. No law can be made that violates basic structure, and because no law can be made that violates Constitution. And Constitution in itself cannot violate basic structure. So that's why every law has to comply with this basic structure requirement, despite the fact that primarily basic structure doctrine was brought in order to ensure that Parliament does not amend the Constitution in a manner that violates the sense of the Constitution. So basic structure doctrine was imagined in the context of constitutional amendment, but the consequence of basic structure is such that even ordinary laws have to comply with basic structure doctrine. Okay. Is that clear? And if you have any questions, let me know. Okay, if there are no questions, then...
Ma'am,
yes.
I have a question. Ma'am, you just categorized the right to property as a legal right.
Yes.
But it's still in the Constitution as Article 300A, if I'm not wrong. So wouldn't that be a constitutional right still? Not a fundamental right,
but a constitutional right is a legal right, right?
So they can be used interchangeably, these two terms?
Yeah, because Constitution is a legal document, so constitutional right is a legal right, per se. Right? Every legal right is not a constitutional right, that is for sure, but a constitutional right is essentially a legal right.
Right, thank you.
Okay, any other questions? Fine, so let me come to the last aspect of basic structure which I would like to discuss, that over a period of time, basic structure has been interpreted, and the content of basic structure has been analyzed in different manners. Now again, I'm just trying to imagine what all questions may be coming in your mind, because these are the questions which were asked in the other section. And okay, explain the concept again. Infuse the entire basic structure. Okay, I'll try to briefly summarize what I said today. So as I told you, basic structure doctrine, in a sense, in a very simplified manner, is that aspect of the Constitution which cannot be amended, which cannot change. Okay. That means that these are the characteristic feature of the Constitution, or the identity marks of the Constitution, such that if you amend the basic structure, what you are essentially doing is that you are bringing about a new Constitution. So let's say if tomorrow we do away with federalism, we do away with right to equality, we do away with secularism, we do away with separation of power, we will not have the Constitution that you have now. It will be a completely new Constitution. Because these aspects like federalism, separation of power, Article 14, 19 and 21, etc. are essential features, or are immutable features of the Constitution. They are the identity marks of the Constitution. So if you change these identity marks, you will in a sense be bringing a new Constitution itself. Now, having said so, what basic structure, as I told you, was born out of a struggle out of conflict between legislature and executive on one hand and the judiciary on the other hand, wherein the argument was whether the the power to decide what the constitution should be vests in the legislature, or does it, or the parliament, or does it vest in the judiciary? Now, because of the advent of basic structure doctrine, now because the contents of basic structure are determined by the judiciary, and basic structure is now a limitation on the power of the parliament to amend the constitution, the final arbiter of constitution is now the judiciary. Because how does it happen? Parliament can amend the constitution, but cannot amend basic structure, right? So there is a limitation on the power of the parliament in the form of basic structure. But who determines what are the contents of basic structure? The judiciary. So basically, judiciary will determine the limitations on the power of the parliament in the form of basic structure. That means that when it came to this contestation between who should be the final arbiter of the constitution, the balance of power shifted in favor of judiciary because of the promulgation of basic structure doctrine. And this is actually one of the critiques of basic structure also, that what basic structure eventually did was that while it was formulated in order to limit the power of the parliament, it ended up giving unlimited power to the judiciary. Now, the critique was not that stark when judiciary was not accused of misusing the power, but whenever there is any incident that makes us question the acts or conduct of the judiciary, we often end up questioning whether basic structure was a good doctrine or not. So there are several therefore critiques of the basic structure itself. One of the critiques being that who is going to limit the power of the judiciary, especially since the judiciary is determining what the constitution should look like. So there must be some form of limitation which should be made on the judiciary itself. Those are the several critiques of basic structure. But essentially, basic structure is about the fact that there are certain immutable principles of the constitution which cannot be changed. And if they are changed, it would lead to constitution losing itself. Very similar to an individual, right? So every individual has certain characteristic features, and if those characteristic features of individuals are changed, we feel as if the individual has become a completely new person. Very similar to that if you change these very characteristic features of the constitution, it would amount to having a new constitution altogether and not the same constitution that we have today. Now, this is basic structure. Now, how do you determine what basic structure is? So, as I told you in Golaknath's judgment, the court had held that the limitation on the power of the parliament to amend the constitution is part 3 of the constitution. So, Parliament can bring about a constitutional amendment under Article 368 of the Constitution, but only to the extent that it does not violate any of the provisions mentioned under Part 3. Now, Keshwal and Bharti case agreed to the fact that there are certain limitations of the power of the Parliament to amend the Constitution, but it did not agree to the fact that Part 3 of the Constitution, that is, fundamental rights, are those limitations. Rather, what it said is that basic structure are those limitations. And what is basic structure would be determined by the judiciary. The contents would be described by the judiciary. Now, please know that entire Part 3 of the Constitution does not form a part of basic structure. There are only certain essential features of Part 3 of the Constitution which form a part of basic structure, like, for example, the trinity of Articles 14, 19, and 21. They are a part of basic structure. But not all aspects of Part 3 of the Constitution are a part of basic structure. Okay, there is a question. Is alien? So I hope you understood basic structure. If not, just let me know. I will repeat it again. There is a question: if alien Jabalpur case violates basic structure. Okay, what you need to understand is that technically judicial decisions cannot violate basic structure. It's only the Parliament, if it is either bringing about a constitutional amendment or in the manner that I explained, a law that can violate a basic structure. Judicial decisions cannot violate basic structure, technically. Okay. Very similar to the fact that judicial decisions cannot violate fundamental rights, according to our understanding of Part 3 of the Constitution, because judiciary is not a state under Article 12. And in order to claim a violation of fundamental rights, you will first have to prove in almost all the fundamental rights, except few, like 17 and 23, you will have to prove that the violating entity is a state, and judiciary is not a state under Article 12 of the Constitution. Very similar to that, judicial decisions per se cannot violate basic structure, because basic structure doctrine is not applicable on judicial decisions. It is applicable on exercise of constituent power by the Parliament. So basic structure doctrine is a limitation on under Article 360, substantive limitation under Article 360. It is not a limitation on judiciary. It is a limitation on the constituent power of the Parliament. I hope Ravikant you understood this fact. And basic structure is not a limitation on judiciary, it is a limitation on constituent power of the Parliament. So in that sense, you cannot actually argue that basic structure is a violation of ADM Jabalpur is a violation of basic structure, though you may critique ADM Jabalpur and say that it goes against the constitutional authority. Theoretically, you can say that, but you cannot raise this argument before the court and say that ADM Jabalpur case is a violation of basic structure, because judicial decisions, basic structure, as I said, are not limitation on power of the judiciary to deliver judicial decisions. Rather, they are a limitation on the power of the Parliament to exercise constituent power. Okay. Any other question if you have? Okay, if you don't have any question, maybe we can wrap up the class for today. And as we discussed before, we will have. Okay, you already have it to do. Okay, sir. You won't be having a class on Saturdays until and unless you want me to schedule a class. Okay, I'm open to scheduling a class if you think that there is a requirement and if you need to clarify certain concepts, and I'm open to having a class on Saturdays itself. But otherwise, as a default, we are not having, at least at the time. I may think, if I feel that there is a requirement, we will definitely have a class, but at least tomorrow we are not having a class. So, until and unless, if you feel the requirement to have a class, please let me know by tonight. Then we can schedule a class for tomorrow. Otherwise, we meet on Monday, okay? And Monday we will maybe discuss if you have any queries regarding basic structure. And we will start a discussion with two cases, Keshwan and Bharti in higher court law. They are both a part of your judgment, part of your unit 1. So in next week onwards, we will try and we have dealt with the conceptual part of unit 1, more or less, because two important ideas had to be discussed, federalism and basic structure. So from next week, we will try and look into the case laws which are mentioned in your unit 1. And analyze what is the relevance of those case laws vis-a-vis these two concepts that we have discussed. Okay, so let's conclude for today now, and then we'll move on Monday. Thank you, everyone.